Bismillahirrahmanirrahim. Today we will cover Sunni Inheritance Law. In this session, we will divide our lecture into four main parts. First of all, we will go through all the Quranic verses on inheritance law. Then we will look into types of legal heirs. And then we will look into principles of distribution of inheritance. And finally, we will explore stages of distribution of inheritable property or estate under Islamic law. Quranic verses on inheritance law. There are three verses of the Quran. The first verse is about inheritance of children and parents. Allah thus directs you as regards your children's inheritance, to the male a portion equal to that of two females. If only daughters, two or more, their share is 2/3 of the inheritance. If only one, her share is a half. For parents, a sixth share of the inheritance to each if the deceased left children. If no children and the parents are the only heirs, the mother has a third. If the deceased left brothers or sisters, the mother has a sixth. The distribution in all cases is after the payment of legacies and debts. Ye know not whether your parents or your children are nearest to you in benefit. These are settled portions ordained by Allah. Allah is all-knowing, all-wise. Then there is another verse with respect to inheritance of spouses and siblings. In what your wives leave, your share is half if they leave no child, but if they leave a child, you get a fourth after payment of legacies and debts. In what ye leave, their share is a fourth if ye leave no child, but if ye leave a child, they get an eighth after payment of legacies and debts. If the man or woman whose inheritance is in question has left neither ascendants nor descendants, but has left a brother or a sister, each one of two gets a sixth, but if more than two, they share in a third, after payment of legacies and debts, so that no loss is caused to anyone. Thus, it is ordained by Allah, and Allah is all-knowing, most forbearing. Inheritance of siblings. They ask thee for a legal decision. Say, Allah directs thus about those who leave no descendants or ascendants as heirs. If it is a man that dies leaving a sister but no child, she shall have half the inheritance. If such a deceased was a woman who left no child, her brother takes her inheritance. If there are two sisters, they shall have 2/3 of the inheritance between them. If there are brothers and sisters, they share. The male have twice the share of the female. Thus doth Allah make clear to you his law, lest ye err. And Allah hath knowledge of all things. The Shani Nuzul, or the occasion of revelation of these verses, is that verse Surah Nisa 11 was revealed when a companion of the Prophet Muhammad, peace be upon him, was martyred, leaving behind his wife and two daughters. After his martyrdom, his brother took control of all his belongings in accordance with the prevailing Arabian customs, without giving anything to his wife and daughters. Thereupon the wife of the companion, along with her daughters, came to the Prophet, peace be upon him, and complained that she would not be able to wed her daughters without having anything from her husband's estate. In this context, the above referred verse was revealed. Thereafter, the Prophet, peace be upon him, ordered the paternal uncle to give away two-thirds of his deceased brother's estate to his daughters and 1/8 to his wife. Inheritance of son and daughters, the Quran states to the male a portion equal to that of two females. Following rules are derived from it. If a deceased leaves behind one son and one daughter, the son will have double the share of the daughter. If there are a number of children without there being any other legal heir, each son will have double the share of each daughter. If there are other legal heirs along with children, they will have their prescribed shares and the rest will be distributed amongst the children in such a manner that each son will have double the share of each daughter. If a person dies leaving behind only one son, he will inherit all the estate. If there is one daughter, she is entitled to a half of her parents' estate. Descendants, males and females of sons, step into shoes of deceased children in case none of them is alive. The verse refers to children generally, which is construed to include children of sons and not children of daughters, according to Sunni schools of thought. Inheritance for parents. The Quran states for parents a sixth share of the inheritance to each if the deceased left children. If no children and the parents are the only heirs, the mother has a third. If the deceased left brothers or sisters, the mother has a sixth. Following rules are derived from this verse. If a deceased leaves behind his parents, along with children, each one of the parents will have 1/6 share in his estate. If there is no child alive, his mother will inherit 1/3 from his estate and the rest will be given to his father. The verse does not specifically state the share of the father in this situation, but the same is derived from the verse by jurists. If there are brothers and sisters, two or more, along with parents, deceased mother will have 1/6 share in the estate and the rest will be inherited by his father. His brother and sisters will not have anything in his estate in presence of his father, as the latter excludes the former from inheritance. Inheritance of spouses. The Quran states, in what your wives leave, your share is a half if they leave no child. But if they leave a child, you get a fourth after payment of legacies and debts. In what ye leave, their share is a fourth. If ye leave no child, but if ye leave a child, they get an eighth after payment of legacies and debts. Following rules are derived. If a wife dies leaving behind her husband without any child, the husband will inherit 1/2 of her estate. If she dies and there are children along with her husband, the husband will inherit 1/4 of her estate. If husband dies leaving behind his wife without any child, she will inherit 1/4 of his estate. If a husband dies and there are children along with his wife, the wife will inherit 1/8 of his estate. Inheritance for uterine brothers and sisters. The Quran states, if a man or woman whose inheritance is in question has left neither ascendants nor descendants, but has left a brother or a sister, each one of two gets a sixth. But if more than two, they share in a third. There are two important points to be noted before we derive rules from this part of the Quranic verse. First, this verse is applicable to such a deceased who dies without leaving any ascendants or and descendants. It means if there is any ascendant or descendant, the heirs mentioned in the verse will not have any share in the deceased estate. Second, based on the consensus of Fuqaha, this part of the verse refers to uterine brothers and sisters only and does not include other categories of brothers and sisters, that is, full and consanguine brother and sisters. Uterine brothers and sisters are the ones who are related to a person through their mother. So mother is the same, but fathers could be different. It's a situation where a woman gets married, she has children, and then either she is divorced or her husband dies, she marries someone else, and then she has children from her second marriage also. So the children from the first marriage and the second marriage, their mother is the same, and they are the uterine brothers and sisters. Inheritance for uterine brothers and sisters. There are two rules of inheritance laid down in the previous mentioned part of the verse. Firstly, if a deceased leaves one uterine brother or one uterine sister behind, each of them will inherit 1/6 of his estate. Secondly, if a deceased leaves behind two or more than two uterine brother and sister, they will inherit 1/3 of the deceased estate, and thereafter this share will be distributed amongst them on equal basis, irrespective of their gender. Inheritance for full or consanguine brothers and sisters. They ask thee for legal decisions, say Allah directs thus about those who leave no descendants or ascendants as heirs. If it is a man that dies leaving a sister but no child, she will have half the inheritance. If such a disease was a woman who left no child, her brother takes her inheritance. If there are two sisters, they shall have 2/3 of the inheritance between them. If there are if there are brothers and sisters, they share, the male having twice the share of the female. لِلذَّكْرِ مِثْلُ حَظِّ الْأُنْثَيَيْنِ. There are two conditions. First, there should not be any ascendants or descendants, either parents or children of the deceased, alive, because in presence of even one of them, consanguine or full brother and sisters will not have any share in the estate. Second, full brothers and sisters are preferred over consanguine brothers and sisters. It means that if there are full brothers and sisters along with consanguine brothers and sisters, the latter will be excluded from inheritance. Following are the rules of inheritance for full brothers and sisters. The same rules are applicable to consanguine brothers and sisters in the absence of full brothers and sisters. If a deceased leaves behind a full sister only, she will inherit 1/2 of his estate. If a person dies leaving behind two or more than two full sisters only, they will inherit 2/3 of his estate. If a person dies and there are full brothers and sisters, they will share his estate in such a manner that each full brother takes double the share of each full sister. If a person dies leaving behind only one full brother, he will inherit all of his estate. And if there are two or more than two full brothers, the deceased estate will be distributed amongst them equally. Based on the Quranic verses, we can divide legal heirs into three categories. First are the sharers or the Zawil Furud mentioned in the Quran. Second are the residuaries or asabat, based on Arabian customary practices sanctioned by the Quran and Sunnah. And the third are the distant kindred or Zwil Arham. Let's look into the details of sharers or Zwil Furuz. There are 13 in number, 4 males and 9 females. Males include father, true grandfather, uterine brother, and husband. Females include wife, mother, daughter, son's daughter, full sister, consanguine sister, uterine sister, paternal grandmother, and maternal grandmother. Residuaries or asabat. Asabat singular is asaba, literally means man's relationship with his father. Asabat or the residuaries refer to those male relatives whose share is not specified or fixed like sharers, but their proximity of relationship with the deceased make them entitled to inheritance of the residue of the estate after giving sharers their due share. Son, son's son, full brother, consanguine brother, and paternal uncles are included in this category. There are two important attributes of residuaries. Firstly, if there are residuaries alone, they will inherit entire estate. Secondly, if there are sharers along with residuaries, the latter will inherit the residue of the estate once the former have taken their respective shares. What are the legal foundation for inheritance of residuaries? They are based on the Arabian custom sanctioned by divine sources, the Quran and Sunnah. There is a hadith reported in the Sahih al-Bukhari about which states that after giving away fixed shares to the sharers, the balance will be inherited by the nearest male residuary or residuaries. There are three types of asabat or residuaries. Residuaries in their own right, asaba bi nafsihi. Residuaries in another's right, asaba bi ghairihi. And residuaries together with another, asabat ma ghairihi. We will look into the details of each of the subcategory of residuaries now. Residuaries in their own right, or asaba bi nafsihi. This category includes those male relatives of a deceased who are related to him without intervention of a female relative. Male descendants of the deceased how low soever, which includes son and son's son. Male ascendants of the deceased how high soever, it includes father and true grandfather. Brothers of the deceased, full and consanguine brothers, and their male descendants how low soever. And brothers of male ascendants of the deceased and their descendants how low soever. This group is comprised of uncles, either full or consanguine, and their male children, such as full uncle's son and consanguine uncle's son. Residuaries inherit after sharers. Residuaries are entitled to inherit the residue of the estate after its distribution to sharers. Consequently, if the estate is consumed entirely by sharers, nothing will be left for residuaries to inherit. For instance, if a woman dies and leaves behind her husband, a full sister, and a consanguine uncle, husband will get one half because there are no children, and the other half will go to full sister. Consanguine uncle will get nothing as the entire estate has been vested in the sharers. Modes of preference among residuaries. Preference on the basis of different directions of relationship to the deceased. For example, male descendants, son's sons are preferred over male ascendants, father, grandfather. Preference on the basis of various levels of relationship to the deceased. For example, son will be preferred over the son's son. And preference on the basis of proximity of relationship with the deceased. For example, full brother will be preferred over consanguine brother. Residuary in another's right, asaba bi ghairihi. This category of asaba is comprised of 4 female relatives. They are sharers originally, but are converted into residuaries because of the presence of male relatives. That is why they are known as residuaries in another's right. They are converted into asabat when a male from their own category having a same level of relationship with the deceased joins them. The females are the following. Daughter of the deceased converts into asaba bi ghairihi when there is a son. Son's daughter of the deceased becomes asaba bi ghairihi when there is a son's son. Full sister of the deceased converts into asaba bi ghairihi when there is a full brother. And consanguine sister of the deceased becomes asaba bi ghairihi when there is a consanguine brother. What is the legal authority for residuaries in another's right? Asaba bi ghairihi. The inheritance of asaba bi ghairihi is derived from different Quranic verses, and their relevant parts are the following. Allah thus directs you as regards your children's inheritance to the male a portion equal to that of 2 females. لِلذَّكْرِ مِثْلَ حَظِّ الْأُنْثَيَيْنِ. If there are brothers and sisters, they share the male having twice the share of female. لِلذَّكْرِ مِثْلَ حَظِّ الْأُنْثَيَيْنِ. Residuaries together with another asaba ma ghairihi. This category of asabat is comprised of females only. There are sisters, either full or consanguine, along with daughters. Daughters of the deceased convert full or consanguine sister, one or more than one, into asaba ma ghairihi, provided that the deceased does not have any male issue. The daughters here are inclusive of son's daughter, how low soever. In this category, full consanguine sisters are converted into asabat, while the daughters who are instrumental in converting them will have their share as sharers and will not become asabat themselves. This is based on the saying of the Prophet, peace be upon him, regard sisters as residuaries asabat along with daughters and granddaughters. Here are a few examples to illustrate the previous principles. If somebody dies and leaves behind 2 daughters and 2 sisters, 2 daughters will get 2/3 of the share and 2 sisters will get the residue, that is 1/3. Daughter and consanguine sister, daughter will get 1/2 and consanguine sister will get 1/2. There are 3 important principles of distribution of inheritance. We will go through them one by one. The first principle is principle of exclusion or hajab. Hajab literally means exclusion or prevention. Technically, it refers to that process in Islamic law of inheritance wherein heirs are excluded from inheritance partially or completely. An heir may be excluded from inheriting an estate of his deceased relative in case there are more preferred heirs than him or her. Following legal heirs cannot be excluded completely. children, such as both son and daughter, parents, both father and mother, and spouse, both husband and wife. Male heirs totally excluded by other heirs. A true father is excluded by a father. A true father who is nearer in his relationship to a deceased will exclude the remoter true grandfather. A full brother is excluded by a father and a male descendant, that is, son or son's son. A consanguine brother is excluded by those who exclude a full brother, that is, a father and a male descendant. A full brother, a full sister, when she becomes asaba ma ghairihi, the residuaries together with another. A uterine brother or sister is excluded by a male ascendant and a male and female descendant. A son's son is excluded by a son. Similarly, a son's son will exclude the other remoter male descendants, that is, a son of son's son, how low soever. A full brother's son is excluded by a father or true grandfather, a son or a son's son, and a full and consanguine brother. A consanguine brother's son is excluded by anyone by a full brother's son and all those who exclude a full brother's son. A full uncle is excluded by a consanguine brother's son and all those who exclude consanguine brother's son. A consanguine uncle is excluded by a full uncle and all those who exclude a full uncle. A full uncle's son is excluded by a consanguine uncle and all those who exclude a consanguine uncle, and a consanguine uncle's son is excluded by a full uncle's son and all those who exclude a full uncle's son. Female heirs totally excluded by other heirs. A paternal or maternal grandmother is excluded by a mother. A son's daughter is excluded by a son and a two or more than two daughters, except when she becomes asaba bighairihi, the residuaries in another's right, along with a son's son. A full sister is excluded by a father and any male descendant. A consanguine sister is excluded by a father, any male descendant, two or more than two sisters, and a full sister when she becomes asaba ma ghairihi, the residuary together with another, and a uterine sister is excluded by a male ascendant and a male and female descendant. Second principle is principle of rad or return. Rad literally means return or coming back. Technically, it refers to a situation where the calculated shares of heirs are lesser than the supposed shares of an estate. Therefore, the residue is distributed amongst the sharers once again. This method is only applied when there is no residuary. This is because if there is a residuary, he or she would inherit the rest of the estate and no residuary would be left. There are few observations regarding the application of the principle of rad or return. Firstly, all sharers are entitled to benefit under its application except spouses. Secondly, a father, grandfather of a deceased are categorized as sharers and inherit as fixed share out of an estate in presence of his children. But if there is no child of the deceased, they convert into residuaries and inherit the residue of the estate. So, in the presence of a father, grandfather, vad is not applicable as the residue of the estate which could have been subjected to Rad would be taken away by any of them as a residuary. Sharers eligible to inherit an estate under principle of Rad or return include daughter, son's daughter, full sister, consanguine sister, mother, true grandmother, uterine sister, and uterine brothers. Third principle is principle of owl. It means excess or surplus. This principle is applied in a situation where the calculated shares of the sharers are more than the supposed shares of an estate. There are two alternatives. In the case where the calculated shares of the sharers are more than the supposed shares, decrease the quantity of each share by increasing the number of the supposed shares, or reduce the shares of only those legal heirs who are sometimes sharers and other times residuaries. For example, daughters, sisters, etc. The majority of scholars are in favor of the first alternative. Please note that the principle of all is opposite of principle of Rad. In case of Rad, there is surplus value left after dividing it amongst the legal heirs. And then surplus is returned to the existing legal heirs. In all, what happens is that the calculated shares of the legal heirs are more than the supposed share. So here, in contrast with principle of Rad, where surplus is distributed, here the shares, the calculated shares have to be reduced to cover this situation. Here are a few examples. For instance, somebody died and left behind husband and two sisters. Because there are no children, husband gets 1/2 and full sisters get 2/3 of the property. Now, here is a very small and very easy process of mathematics involved. Please don't be scared with this. The way we calculate is that the LCM or least common factor between of 2 and 3 is 6. Yeah. And then when we divide 2 by 6, we get 3. And then this is how we get the share of husband, that is 3. So if you divide 6 by 2, so 2 would be 3. And then we will multiply 3 with 1. And this is how we get 3 by 6. And when we divide 6 by 3, that is 2. And then we multiply 2 with 2 and we get 4. This is 4 by 6. Now, the total number of calculated shares is 3 plus 4, 7. So here 3, that is husband's share, and 4, that is full sister's share, is 7, while the supposed shares are 6. So the supposed share will be increased to 7, and the shares will actually inherit, and the sharers will actually inherit from the estate the following shares. Husband will get 3/7 instead of 3/6, and full sisters will get 4/7 instead of 4/6. It's simple and straightforward. The third category of legal heirs is called distant kindred or Zawil Arham. Arham is plural. Arham is a plural of Raham, which refers to a mother's womb. This meaning might give an impression that Zawil Arham or distant kindred is confined to the relatives from mother's side. However, it is not restricted to them and include the relatives from father's side as well. The relatives who form part of Zawil Arham Their share is neither fixed under Islamic law like sharers, nor are they entitled to the residue of an estate like residuaries. Some examples of distant kindreds are paternal uncle's wife, maternal aunt, maternal uncle, sisters, children, and daughters' children. Now let's look into the stages of distribution of inheritable property or estate. So far, we have looked into three categories of legal heirs, that is, sharers, residuaries, and distant kindreds. And we also have looked into three principles of distribution of estate. The first principle is principle of exclusion, where some legal heirs exclude the others. The general rule is that the nearer in relationship to the deceased will exclude the remoter. Second principle is principle of rad or return. Sometimes when property is divided, there is residue left. And then that residue is again divided according to the respective share of the legal heirs. And the third principle is principle of owl, which is exactly the opposite of principle of rad, because in owl, the actual shares are lesser than the spouse shares. And then the whatever is the amount of lesser shares that is divided amongst the legal heirs. So in return, the existing legal heirs get extra in all their existing shares are reduced. So these are the three principles. Now, let's look into the stages of distribution of inheritable property. So what stages or what processes are applied when a person's estate is divided amongst his or her legal heirs? The sharers or Zawil Furud, they are the first to inherit. Their shares are fixed in the Quran, Sunnah, or Ijma. The residuaries or asabat are entitled to the residue of the estate once it has been appropriated by the sharers to the extent of their respective shares. If there is no sharer, the entire estate will be inherited by the residuaries. If there is only one residuary, he or she may inherit the entire estate of the deceased, but if there are more than one residuaries, the nearer in degree will exclude the remote relatives. Return or rad to Zuil Faruz if any estate of a deceased has not been appropriated completely by the sharers and there is no residuary to inherit its residue, the estate will be returned to the sharers or Zawil Furud. They will once again be entitled to inherit from the same estate. The manner of distribution amongst them will be determined by their respective shares. Spouses are not entitled to benefit from it at this stage of distribution. Distant kindreds will arham. These are the relatives of a deceased who are neither sharers nor residuaries. For example, maternal uncle, maternal aunt, paternal aunt, daughter's son, and daughter's daughter. They will be entitled to inherit in the absence of residuaries and sharers except the spouse of a deceased. Return or rad to one of the spouses. The estate of a deceased is returned to one of the spouses if there is no sharer, residuary, or distant kindred. Beneficiaries under a will, if someone has been bequeathed more than one third under a will, he or she would be entitled to receive the same provided there are no sharers, residuaries, or distant kindred. If the estate is not fully consumed after giving share to beneficiary under the will, it will be deposited in the public treasury, that is Baitul Mal, for the benefit of Muslim community. We recommend that the following readings for further information relating to Islamic inheritance law.